I'm Liz McGill. I'm the Vice Dean at the Law School, and we're here this afternoon to discuss Professor Ted White's new book, Law in American History, Volume 1, From the Colonial Years to the Civil War. Our panelists are going to discuss this book in detail, so I thought I might introduce the panel by telling you a little bit about Professor White. He is the David and Mary Harrison Distinguished Professor of Law at the Law School here. He's been a member of our faculty since 1972. You can do the math on how many decades that means. In that time, he has published 15 books. This is his 15th, and by my count, over 120 articles. To make that a little more concrete, that means that every year Ted has been in law teaching. He has completed about a third of a book and 3+ articles. Just as impressive, I think, Professor White is constantly mastering new ground. He's written on legal developments in the 19th century and the 20th century. He's written judicial biographies, he's written synthetic interpretive accounts, he's written on private law, he's written on constitutional law, he's written on baseball, and he's written on algebra. His scholarship has won at one time or another every scholarly prize that a person working in his fields could win. It's impossible to summarize his many scholarly accomplishments, but let me talk about a couple of his most important works. Ted's book on the Marshall Court and Cultural Change is an entry in the Holmes Devise, History of the Supreme Court. In this book, he has written what many regard as the best entry in the series to date. Earlier entries in this series consisted of quite detailed presentations of Supreme Court doctrine and cases without any attention to the context in which those cases were decided. White turned his volume into a real history relating the court's developments to political, economic, and cultural change outside the Supreme Court, and also delved into the internal workings of the federal judiciary and the Supreme Court. As one scholar put it, White's book, quote, changed the scholarly aspirations of the Holmes Devise series. Future volumes are being written in pursuit of the White model of genuine history. Professor White's multi-volume biography of Justice Oliver Wendell Holmes, I think, is similarly genre-defining. It is acknowledged as the best biography of Holmes, and there are competitors for that prize. It has been called by several reviewers a masterpiece, and by one, quote, the best biographical work ever written on any American judge. It is often presented as a model for other judicial biographers. I've just scratched the surface of Ted's astonishingly successful and productive career. We're gathering today, I think, equally astonishingly, to discuss an entirely new venture by Professor White. He has undertaken he's committed to write a 3-volume series on law in American history. We're talking today about just Volume 1, which dates from the colonial period to the Civil War, as I said. In his introduction to this book, Professor White says that one could call this book, quote, some arguably central themes of American history and how law is seen to relate to them, offered with deference and my compliments to the gentle reader. That sentiment is quite appreciated by this gentle reader, but I think the panelists will reveal to you today that that undersells the scope and ambition of the project. 3 legal historians are going to help us unpack this book. I'll introduce each of them now. Professor Tomiko Brown-Nagin of our faculty is the T. Munford Boyd Professor and Justice Thurgood Marshall Distinguished Professor of Law and Professor of History. Professor Brown-Nagin is an expert in 20th century social and legal history and has written widely on civil rights law. She is the author of the recently published Courage to Dissent, a book about lawyers, courts, and community-based activism during the civil rights era. Professor Fred Kanevsky is the University at Buffalo Distinguished Professor. He is an expert in 19th century American legal history. He edited the papers of Daniel Webster. He's written many articles on 19th century legal history and is now at work on a book about Simon Greenleaf, a mid-19th century law professor at the Harvard Law School. Professor John Witt is the Alan H. Duffy Class of 1960 Professor of Law at the Yale Law School. He writes in the history of American law and in torts. His first book, The Accidental Republic, Crippled Working Men, Destitute Widows, and the Remaking of American Law, which was a history of the origins of workmen's compensation, has been called masterful, and it won many prizes, including the James Willard Hearst Prize from the Law and Society Association. Witt is now working on a book about the laws of war in American history from the Revolution to the turn of the 20th century. So here's how we'll proceed. Each panelist is going to speak for about 15 minutes. Professor White is going to respond, and then we'll take some questions from the audience and hopefully have some exchange. And then we will adjourn to a reception that will occur over there to further discuss the book. Thanks for coming. Professor Brown-Nagin.
Good afternoon to all of you. So glad to be here. Thank you, Ted, for inviting me to be a part of this illustrious panel to celebrate the publication of the first volume of Law in American History. This is such a treat for me. It's also very humbling to be a part of the attempt to characterize your great work, your past work, and what you've done in this book. And yet I'll start off by saying that I think it's quite an achievement. It is a tremendous addition to Ted's substantial body of work. It's a work that in some ways stands apart from the scholarship for which he is best known. And I hope that it'll be useful for me to start off by providing a brief overview of Ted's work to date with the view towards trying to give you an idea of the innovations of his new work. Now, as many of you know, Ted wrote the book on much of constitutional and legal history as it's classically conceived. He's an eminent historian of the Supreme Court as an institution. He is a biographer of great jurists, Marshall, Holmes, and Warren, and no one can really contest the significance of Ted's work in these areas, certainly not the biographies. As I have learned myself, I found myself this past fall curled up with several of those biographies, as well as the American Judicial Tradition volume, in order to try to learn something of the craft, as I hope to try my own hand at biography. And those works are simply brilliant. If I'm forced to choose a single label for Ted, I think I'd say that he's an intellectual historian of the law and its institutions. He asks questions about how the courts came to be so central in American life, what makes courts distinctive, what gives them credibility among other institutions of government, and he's consistently argued that courts are constrained by the logic of the law itself and by the limited role that courts play in our democracy. In a field in which many have become enamored of the impact of society on the law, Ted insists that law in and of itself matters. Text matters, doctrine matters, judges are professionals. This is a classic approach to legal history. So the question is, what remains of that signature approach in this most recent work? Well, in short answer, much remains of the signature approach. Ted keeps his concern with the courts and with their roles and obviously with judges to a significant degree. His understanding of the law, however, I think is more broadly conceived. I'll get to that point in a few minutes. At the same time, his main innovation here is to offer us, to write for us, a synthetic treatment of American law. And even as I say that, I want to pause and underscore, italicize, boldface, the significance of writing a synthetic treatment of legal history. This is really, really phenomenal to be able to do it well. It takes a person who knows a lot, a person of tremendous depth of knowledge, tremendous range, tremendous ambition to write a book called Law in American History, Volume 1, which is what Ted has done. And Ted is that person to be able to pull off this kind of work. He's read enough over the years, he's learned enough over the years that he's able to stitch together the parts of legal history to make a comprehensible whole. Now, what does he bring together in this volume? I would say that Ted integrates several bodies of specialist history into the study of law and the courts. He visits Native American history, the law of slavery, the law of gender and the family and the household. He touches upon commerce and economic development. He covers the legal profession, among other topics. This is a cross-disciplinary work. It is trans-substantive. There are bits of everything in this work. Now, what of methodology? Well, Ted brings together all of these subjects and disciplines, and he maintains one element of his signature methodological perspective. Ted writes against a school of legal history, which is associated with another eminent legal historian, Lawrence Friedman, that views law as, quote, a mirror of society. And I emphasize this particular language because Ted emphasizes it in his own work. Now, what does this mean? Well, on this account, law is not autonomous. It is essentially a byproduct of interest group conflict. Now, Ted, by contrast, takes law on its own terms. He says he takes the logic of the law very seriously. He takes the cases very seriously and the courts seriously, as I mentioned when I started. But he does so by paying attention to context, to those external considerations that he deems important at certain historical moments. And he causes a selective understanding of history. Now, in this particular volume, the elements of context that he views as important are cultural forces, including republicanism, the search for permanent settlement, as well as these aspects of tribal history, the law of slavery, and so forth, as I've explained. Now, so I think that in no small part, Ted, who is this externalist legal historian par excellence, has, in this particular volume, significantly broadened his methodological orientation. Although I won't actually label this. I don't think Ted likes these labels, but I would pose a question for him that is important and unanswered, and that's the question of how his view of law and history relates to another important orientation in the historiography, and that is the famous critique of legal functionalism by Robert Gordon. Gordon famously argued that law is both constitutive of society and indeterminate. Perhaps Ted later on can speak to those in the audience who are interested in historiography about precisely how he would see his methodological orientation now that he's published this book, or maybe he won't do that. We shall see. Now, for the remainder of my remarks, I'll focus on three aspects of this work that I found really rewarding. I'll discuss law and tribal history, law and slavery, and law and the agricultural household, with some references to Ted's treatment of the emergence of the Supreme Court. First, with respect to Native American history, the important contribution here is to integrate Native American history into the study of legal history. Ted does much more of this than I've seen in any synthetic treatment of American legal history. And he's to be heartily congratulated for this, in my view. And I'm quoting, "The near silence of the majority of scholars of American law and politics on the topic of Indian law," wrote one scholar in 2001, "is no mere forgetting of one of America's margins. It is a strategy of marginalizing the foundational." Now, that statement was made in a review of the leading synthetic treatment of American legal history, although not the current edition. Now, you might say, well, that was 2001, this is 2012. Well, as it happens, that critique continues. As recently as the December 2011 issue of the Journal of American History, three scholars, prominent scholars of Native American history, continue to talk about how Native American history is segregated from other forms of history, and they called for the merger, the integration of this history into all other forms of history. Ted's attention to this subject in his treatment is thus very important. It's important for the field of legal history. It's important for Native American history. And I say this in part because of Ted's stature in the field, of course. It's important that Ted is the person who is doing this integration. His attention to Native American history, particularly during the colonial era, gives legitimacy to the subject matter. Now, what's a specific contribution? Well, what he's showing here is that once upon a time, colonial courts acknowledged indigenous cultural practices, rituals, and traditions, all elements of what he calls tribal law. Now, why is this important? Well, because tribal law was so different from the law that became important as colonists started to push for permanent settlement in this country. And what are the tensions between tribal law and the law that became dominant in the colonial courts? Well, of course, in tribal law, Ted tells us there is no concept of exclusive land ownership. Treaties are conditional. They're not negotiated with the idea of permanent use of land. There's a concept of shared ownership, communal norms. The overall point about the colonial era is that law is broadly conceived there. It's indigenous, and it includes charters, common law rules, and Native American cultural norms, but this changes by the 18th century when the law becomes more English, as he says. Now, I think this is very important, and I'm shocked to know that I have so little time left, I must say. So I'm going to just hit on some points that I would have made more slowly. This is very important, but I would actually think of what Ted is doing here, not so much as broadening our conception of law, but actually thinking about Native Americans as economic actors. There's a small but growing literature about the interplay of Native American and U.S. economic history that emphasizes or questions what the study of these two together tells us about capitalist development and market economies. The question is whether colonial relations were a condition of U.S. economic development. And the corresponding legal question is what role the law played in that development process. Moreover, there are some scholars who are challenging the idea, an idea that animates Ted's work, that Indians of the colonial era adopted communal norms. And here is a bit of the flavor of some of this work. In this scholarship, Native Americans are not legal and cultural antithesis of the individuals whose profit-seeking was the driving force of the modernizing world. Perhaps more germane to the era that Ted discusses, there's an important scholarship about Native Americans and the slave trade. So it turns out that Indians were both slavers and enslaved. There's a book that won the Bancroft Prize a few years ago that was all about this. I think that this could have tremendous value to the work that Ted does here on Native Americans and the law of slavery. Another point that I would make here is that the culture talk, which is a part of Ted's analysis, does not occur in a legal vacuum. A more complicated view of who Native Americans were as economic actors and a recognition that culture talk occurs in tandem with rights talks really brings us to this question of what role law played in the transformation of a system, transformation of the system from one where both parties thought they were trading with fools, as Ted tells us, to a system where there was European domination. Now, Ted's account of this transformation is pretty descriptive. For instance, he talks of the Marshall trilogy of cases in a way that is mostly descriptive. He doesn't really talk about the text of the cases very much. One learns from his discussion that constitutional law doesn't cause dispossession. The legal rules merely result or permit dispossession. I was a little disappointed in this. I wanted to know more about what Ted thought about those cases. So if Ted is sort of the person who is going to tell us how law has autonomy in and of itself, I wanted to have him discuss those cases in the context of talking about Native American culture. Of course, there are people who would not think of law as having a secondary role in the dispossession of Native Americans. They would say that law is causal. They would talk about the Marshall Court as an engine of capitalist exploitation. They would talk about racial motivations, religion, a lot of other things that are very rich that I would have liked to have seen Ted engage there. His discussion of law and slavery is very rich. I have some thoughts about why he thinks Dred Scott is such a terrible case. I take it from his discussion that the problem is Chief Justice Taney is the antithesis of John Marshall, that it all comes down to the rhetoric. That was a little dissatisfying to me, in part because there are ways in which if Dred Scott is so awful, it's awful for reasons that are much the same reason that a lot of people think Brown is awful. A lot of people think Roe is awful. And so I wanted to know, ultimately, I want to know about the larger implications of that discussion. I've run out of time, and so I will end by simply congratulating Ted on this wonderful achievement of raising the bar for all of us by writing this wonderful synthesis of law and American history. Thank you.
Well, I'm pleased to be here as well. Actually, John and I separately flew in on U.S. Air, so when you get to volume 3, Ted, I'm looking forward to reading the chapter on deregulation in the late 20th century. But I'm pleased to be here as well with Liz and Tomiko and John, whose work I admire so much. But I'm mostly pleased to be here today to help mark this signal achievement, the publication of Volume 1 of Ted's important and ambitious contribution to the field of American legal history. And I'd like to divide my comments into 3 categories of observation. First, a quick contrast of Ted's methodology with previous attempts by others to write comprehensive studies of American legal history. Next, a very brief comparison of this work with a portion of Ted's work in the past. And finally, an evaluation of his substantive claims and arguments in the book. So first, the black hole of methodology. Until now, we've had very few souls brave enough to undertake sweeping and general histories of American law. In some ways, the recent publication of the 3-volume Cambridge History of Law in America, with responsibility divided among 60 authors and distinct voices, might be viewed, ironically, as the official flag of surrender in the search for the unified grand theory attempted by just one scholar. That is, until Ted. But oddly enough, virtually all of those individuals who have courageously risen to the solo challenge have used one metaphor to launch their inquiries and frame their narratives: the mirror. Lawrence Freedman headed us down this path nearly 40 years ago at one of the foundational moments in the late 20th century Renaissance in the writing of American legal history. In the preface to his History of American Law, Freedman famously proclaimed, "This is a social history of American law. This book treats American law then not as a kingdom unto itself, not as a set of rules and concepts, not as the province of lawyers alone, but as a mirror of society. It takes nothing as historical accident, nothing as autonomous, everything as relative, and molded by economy and society. Friedman's methodological insight stemmed in part from his commitment to the early Law and Society movement and the influence on him of the work of his former Wisconsin colleague, Willard Hurst. Friedman sought to wed the two, and in doing so, rejected all possible internalist explanations for legal historical phenomena. The mirror will explain everything. Friedman was followed not too long afterwards by yet another mirror, Kermit Hall's effort to capture the field entitled The Magic Mirror, Law in American History. Hall claimed that his goal was to elucidate the interaction of law and society, and though he acknowledged the impact of Friedman on the field, he sought to separate himself from Friedman by arguing that his book was about law in American history rather than strictly a history of American law. His mirror, however, had a different source, Oliver Wendell Holmes, Jr. In 1885, Holmes delivered a speech to the Suffolk Bar Association in which he noted, somewhat in contrast to other images in the talk, that, quote, "This abstraction called the law is a magic mirror, wherein we see reflected not only our own lives, but the lives of all men that have been." For Hall, therefore, his book was about what the magic mirror reveals to us. It's about law as part of our social history. In a lengthy review of Hall's book, Chris Tomlins expressed a certain impatience with Hall, and to an extent Friedman, and pronounced the mirror not magic, but channeling his inner Lord Tennyson, he found the mirror cracked. By 2005, in the preface to his third edition, Friedman remained adamant and unapologetic. It's still a social history of law, he wrote. It still rejects any notion that law is autonomous. Law is a mirror of society. But then he began to retreat ever so slightly, probably in acknowledgement of the generation of writing in the field. Perhaps, he wrote, it is a distorted mirror. Perhaps in some regards, society mirrors law. And in a nod to Hall and others, he now conceded, surely law and society interact. However, he said, the central point remains. Law is the product of social forces working in society. If it has a life of its own, it's a narrow and restricted life. So there we have it, a short history of the use of the metaphor of the mirror in undertaking the daunting task of writing full-scale, all-encompassing histories of American law. The mirror, magic, distorted, cracked. I offer this as a prelude only to help us understand the backdrop against which Ted is writing so that we can take the full measure of his contribution. For Ted, right at the outset, and for all intents and purposes, announces in the writing of sweeping legal histories that the era of the mirror is over. Instead, he offers an alternative lens for viewing America's legal past. Ted acknowledges that the mirror may be attractive, but he asserts that if one looks a little more closely, the relationship between law and its social context, as he puts it, becomes more opaque. He views the relationship between law and American history as reciprocal and seeks to, quote, explore the simultaneous effect of historical themes on law and law on those themes. In other words, the problem with the mirror has been that it is one way, and Ted is proposing a much more complex and nuanced explanation for the events that constitute America's legal history and a world more directed to relative autonomy in which there is traffic across the bridge both ways between things we call law and forces, social or economic or intellectual or a whole range of distinctive aspects of American life. Law in this telling, quote, is both constitutive and reflective of the culture that surrounds it in any moment in time. In essence, therefore, Ted is the anti-Friedman, or as he would put it more politely, a symbol of the post-Friedman world of American legal historiography. And he squarely locates his alternative position by insisting that his book is law in American history and not a history of American law or law and American history. As a careful historian, Ted views his job or responsibility in rendering the past to as faithfully as possible, quote, recreate the ways in which actors in the past experienced the world, unquote. Law, according to Ted's account, is central to almost everything in American history. It occupies a pride of place, and that is his core methodological and theoretical claim and insight. This may all sound a little like inside baseball, and it runs the risk of replaying the obsessions of an earlier generation of legal historians, but I do not want this important aspect of his book to be overlooked. Second, I would just want to say a brief word about another work of Ted's that reminded me of his new book. In the American judicial tradition, drawing on the model of Richard Hofstadter's The American Political Tradition, Ted sought to do for appellate judges what Hofstadter had done for politicians, analyzing the various styles, techniques, traditions of judicial reasoning. The result was a series of freestanding essays that focused on particular judges at particular times, but also in concert sustained a common theme and historical trajectory. Law in American History can be read as a series of essays held together by a connective tissue of argument, and the book might very well be entitled The American Legal Tradition, or maybe more appropriately, its plural, American Legal Traditions, because one of the underlying subtexts in the book is the deeply contested terrain of law. I say this to help convey one of the real strengths of the book, the many levels at which it operates, while never losing sight of how American law is at the heart of understanding American history. And so with that, I want to turn to the book itself to examine its reach, scope, and contribution. The book seeks to identify certain central themes in the history of America, in some ways measures of American exceptionalism, and then demonstrates how under closer examination law is central to our understanding of these themes. But I do want to slightly recast the categories Ted uses in his book and divide them into subject areas or topics that then lend support to his broader themes or claims. First, the subjects that Ted finds compelling in constructing his portrait of law as an animating force. They're not fully comprehensive. That is, this is not a book that surveys or covers the entire landscape of American history or American legal history. Ted picks and chooses, and a good deal of his evidence comes from public law and not private law and its connection to markets, a gap Ted promises to remedy in Volume 2 when he doubles back to examine the roots of private law doctrine in the period covered by Volume 1. So the subject matters, quite masterfully synthesized from a variety of interdisciplinary sources, range from the colonial period, which includes the exploration of the relationship between the European settlers and the Amerindian tribes, and then the rise of agricultural household life as a cultural norm, followed by the move, for lots of complicated reasons, for independence, and then the stages in the formation of Republican government, succeeded by the emergence of the Supreme Court as a significant legal and political force in the life of the nation, the entrepreneurial push for economic growth and development, culminating in the advance towards dissolving the Union driven by the conflict over slavery, and eventually an examination of the conduct north and south of the Civil War itself, with all its legal and constitutional complications and implications. Those comprise the categories, but within those areas we find lots of examples of social, economic, material, and legal conditions and forms of organization of everyday life, and often at another level, attitudes focusing on race, gender, age, ethnicity weave their way through the narrative. But at critical moments we find tensions between competing legal ideas, formulations, or approaches to the social or economic or political problems. These tensions are often the crucible out of which law is forged. I have time for only a couple of examples. The chapter on the colonial years traces the differences between the settlers and the native tribes on questions of land use and ownership, with disastrous consequences for the tribes as colonial law became increasingly anglicized. Or the relationship between agricultural household life and its landholding patterns, stressing a complex mix of labor regimes with its primary emphasis on bound labor, in which the seeds were planted for the incompatibility between slave and free labor, examples of legal relations as social relations of dependence and hierarchy. Or the struggle in the run-up to the Revolutionary War, between Parliament, the Crown, and the colonies to define on each side the proper legal status of the colonists as members of the empire, with or without the freestanding liberties of citizens protected under the British Constitution. The intricate web of sovereignty, consent, and law lent itself to very different conceptions of the legitimacy of London's intervention through the Stamp Act and other coercive measures within an imperial system that had become an intensely local culture which many colonists perceived as self-governing. Ironically, despite very distinct land and labor systems in the various colonies, the colonists experienced the recent parliamentary directives as uniformly threatening of their landholding and social and economic opportunities. Or there was the tension produced by the process of what we now call creative destruction in capitalism, the simultaneously creation and destruction of worlds, exemplified by transportation networks and competing franchises as improvements and inventions coalesced to form technologies of freedom that enabled some to engage in activities they could only have dreamed of before, at the same time that the freedom of others to continue their lives as they knew it was extinguished. Law wittingly or unwittingly played a central role in the justification of the process of creative destruction. And then, of course, the most dominating tension of all in American life is over the role of slavery, about which more in a minute, or 3 minutes.
Less
than 3 minutes. Ted's actually the official time. If these are the subjects, then what are the central themes that these subjects illustrate? The themes that have driven American history, according to Ted, and to which law is central. First, the removal of the Amerindian population from the tribal settlements and way of life throughout what became the United States, northeast, east, south, west. Second, the introduction of slavery. Third, the vast territorial expansion and population boom of the country, which in some places accommodated slavery and exacerbated sectional tensions leading to the Civil War. Each of these themes are interrelated. The dispossession of Native Americans from tribal land was followed by the demand to fill that land through various types of acquisition that allowed slavery to flourish within the spreading grasp of agricultural labor. Meanwhile, a range of legal and political solutions were pursued to address the increasingly intractable quandary of legalized African slavery existing in a land promising freedom but not equality. Most of the subject areas Ted describes feed some aspect of these themes, whether it be the structure of federalism, linking local authority to more centralized control, built on theories of sovereignty residing in the people in a republican form of government, thereby hamstringing attempts to address slavery systematically or universally as a legal institution, or federal land acquisition strategies, or public land ownership and settlement policies, or the development of transportation networks and infrastructure making movement throughout the nation easier, supported by corporate and financing mechanisms, or the failure of the major institutions of American life, Congress, the presidency, political parties, lawyers, judges, courts, including the Supreme Court, to prevent a war, or the manner in which law assisted the military in conducting a war. All these events and many others in the book show how law both contributed to the unfolding of these three central ideas, and also how those themes cast their shadow on the law. Sometimes the law failed. If we take a step back, the themes Ted so perceptively identified can be framed by two events, both convulsive in their own way, the Revolution and the Civil War. In both instances, we experienced the centrifugal and centripetal forces of law. As the American colonists pulled away first from Parliament and then from the Crown, they also paved the way for their own independence and then renewal, evolving from a focus on separation to a cautious exploration of the conditions of unity. War became the strategy, if not the solution, as competing legal ideas about sovereignty and liberty failed to resolve the conflict. The former colonists thought they had learned their lesson and sought to reconstitute governance to prevent being pulled apart again. Likewise, all the legal strategies and arguments failed to prevent a subsequent dissolution as a nation disintegrated into civil war. The original founding generation thought slavery would disappear as a natural phenomenon over time. They were wrong, as they were repeatedly reminded, and they tried to postpone a reckoning. So once again, the United States confronted separation, dissolution, as Ted puts it, to emerge, as Lincoln phrased it at Gettysburg, with a new birth of freedom. In one of his Civil War poems, Herman Melville exulted that a triumphant battle for the North had resulted in a victory of law, with law capitalized, by which I think he meant a victory of righteousness and union over lawlessness and rebellion. The South had its own view of what was constitutional and legal, and the confrontation showed that the different discourses, even with their own internal divisions, had exhausted all ways to communicate about law. War arrived instead, because in some ways the original attempt at the time of the Revolution to contain or avoid the problem of slavery could no longer be maintained. So this is a book about dissolution, not once but twice, and then the aspiration for regeneration. But it's also a book about both law's capacity and incapacity to mediate between freedom and order, and about the struggle over who gets to define both freedom and order. Ted has shown us how law matters, and also of what matters law is made. We should all recognize this achievement, and we owe Ted a debt of gratitude for producing this fresh, rich, provocative, and what I believe will be an enduring study of American legal history. Thank you.
Well done. It's a real pleasure to be here today. I first encountered Ted's work as a graduate student when I cut my teeth on his Tort Law in America as I was beginning my own project on the history of American accident law in much the same period. And the dread that I experienced going into this project of mine, 15 years ago now, knowing that Ted had already been through the material, I can't adequately express to you now, and I'm grateful that Ted's still willing to invite me nonetheless. I thought what I might say a few words about today, as I thought about how to talk in this kind of a context about a synthetic work on the history of American law, I thought I wouldn't take up any one of the many really interesting topics that Ted delightfully explores in this book. And you've heard a few of them from Professor Brown-Nagin and from Professor Kanevsky. I thought instead I'd ask a different kind of question, a question, why write the history of the law? This is one of the questions, it seems to me, that Ted's work calls to be asked. I mean, Ted's written so much of the history of the law at this point. One wants to know why. What's the aim? What's the project? What's the practice of writing the history of the law? And I ask that in part because it's an awkward question, one that legal historians like to suppress its awkwardness. But I think it's an awkward question. It's an awkward question in history departments where there just hasn't been very much history of the law. The University of Virginia is an important exception to that. But if you look around history departments around the country, the history of the law goes relatively underrepresented at least. In law schools, the embarrassing and troubling question is, well, what's the history got to do with the project of the law school? The law school is designed to answer a set of very difficult institutional and normative questions about the 21st century. And the historian sometimes looks like an antiquarian. The historian brings a set of outdated, probably outmoded facts to bear on questions on which the statute of limitations has no doubt run a very long time ago. So what's the project of writing the history of the law? And I thought what I'd do is spin out a couple possibilities, and they're possibilities that I think are picked up in interesting ways in the text of Ted's most recent book, and really run through much of Ted's work going back a couple of decades now. I should say at the outset that there are some moments in this book in which Ted seems to embrace the antiquarian. This is what I think of as the antinomian strand of this book, in which Ted says, I don't know if this is the right story to to tell. That is, there's so many stories one could tell. This is just the story that I've told. And here's history as a kind of luxury good in the law school. It's a kind of it's a forum for telling stories. One can't be sure if they have much significance. And sometimes Ted modestly strikes this tone in the book. But I don't think, and this is what Liz suggested at the outset, I don't think that's what's going on in this book at all. I think this is a becoming but false modesty in the book. I think there's a project at foot here. And we can see that project from the structure of the book. The structure takes law across time and interweaves it closely with other domains of social life and authority. We see law nestled up close to politics. We see law sometimes swamped, or almost swamped, and that's an important difference, by war. Right? As Professor Kanevsky points out, the book is bookended by two wars, the 7 Years' War at one end and the Civil War at the other. And through it all, Ted makes law the through line. We never lose sight of law and its role in the social controversies of the day. Now, mere antiquarianism wouldn't explain this. That is to say, there's something about the law that's captured Ted's interest and then makes him focus on the law rather than the domain of military history, where surely the antiquarian should stay on the battlefield and describe the munitions being used or the particular firearms that are the cutting edge of the day. But something about the law has captured Ted's interest here. And I want to try to figure out what is it that makes the law interesting in this sense. Now, one possibility, it doesn't really answer the question, but is a popular answer for historians, is that, well, maybe Ted is just trying to seek the truth of the matter. Historians should seek the truth. To tell the story the way it really was. And it's surely the case that myths of all sorts of pernicious kinds float around law schools. There are about as many of them as there are law students in most law schools. And so bringing truth to these myths might be a useful service. Now, this won't explain why study the law, though, since after all there are myths of all kinds. Some of them are legal myths. Some of them are myths about art history. So why is it that we're pursuing the law here? Now, one possibility that's been raised by the mirror metaphor that both Professor Brown-Nagin and Professor Kanevsky have raised is the law might be a proxy for something else. It might be that we want to understand the history of human social life, but human social life is so multifarious, so complicated, so diverse that we can't make sense of it. We can't get our hands around it. But the law might be this magic mirror. It might allow us to tell the history of human society through something we can narrate, something we can get our hands around. And that's one thing going on here, but I agree with both of my distinguished fellow commentators that that's not exactly what Ted has in mind. Another possibility would be law might be a store of lessons from the past. The most prominent right now version of this would be originalism. So originalism as a theory of what history means for the law today. The meaning of the Constitution in the minds of the framers, or better yet, the ratifiers, might capture something about the law today. And this is widespread. It's interesting to note that there aren't many PhDs in history who pursue the originalism project. This is a lawyer's project. And not so much a historian's project. The first move in originalism is the legal theory that gets you to the idea that the meaning of the Constitution in the minds of the ratifiers or the founders is what matters. And that seems to be where the action is. The historian really serves only as the antiquarian sidekick to the legal theorist for originalism. And so there's actually not a trace of originalism in this book. History could be the accumulated store of the wisdom of the ancients. So this would be the value of custom. It would be a Burkean theory of what history brings to 21st century legal questions. And there's a lot of useful value in the idea that custom and codes, things we don't even understand about the way we've organized our social life. And so it's thrown over only at peril of making mistakes that we don't even understand as we go about rationalizing the present. I don't really think this is what Ted's up to either in this book, although there's certainly a respectful treatment of the things that have gone before, in a sense that learning them for their own sake might be useful, and this might be one of the ways in which it would be. History can also be a body of examples, like a set of case studies. Here it might function like a kind of comparative law. It would be an analog to comparative law. We'd be interested to know whether a particular rule or doctrine or institution worked in France or in China. And we might too ask about that other strange country, the past, and look to the past as a source of examples for whether law has the functional capacities to accomplish the kinds of things we want it to accomplish in the here and now in, for example, the United States. And I think there's some of that in Ted's book, but again, it's not the major strand. Another version, not history as lessons from the past, but it would be history as subversion and critique. This is an approach to history long adopted by the adherents of critical legal studies. Now, I say long adopted. There aren't that many adherents to critical legal studies around. They're hard to find these days. But the ideas that the critical legal studies movement introduced for the history of the law are still vibrant and very important. The idea here is that history might reveal that the ostensibly neutral, apolitical institutions and doctrines of the law, which legitimate themselves precisely by their opposition to politics, might actually be saturated by politics all the way down. They might be rooted in political controversies that raised local problems and were posed local solutions to those local problems. And this would be a way of undermining their ostensibly universal authority. Now, I don't think there's a subversive deconstructionist dimension to this book. It's not a prominent feature in Ted White's work over the last 3 decades, to say the least. So I don't think this is what Ted is up to either. It's not really Ted's game, although I will say that one element that features in the narrative is the idea of contingency. So this book is full of moments of contingency and of alternative paths that might have been taken. And that's actually a critical move in this subversive, critical approach to thinking about legal history. So what is going on? Here are a bunch of possibilities I've given you that I don't think really capture what Ted's up to, although they could be plausible projects for a synthetic work of American legal history. I think what's going on in this particular book is that Ted is focused on the significance of law as a social practice in American social life. Let me say a couple more things about that. For the generation of legal historians who wrote synthetic accounts around the mirror metaphor, there were 2 questions. One question was, what is law's constitutive effect? I mean, what is its power? What is the authority that it has? How does it change the world? And so a left critical approach, captured by Morton Horwitz's synthesis, took the law's power for granted and asked, how was the law's power connected to the injustices that were abundantly evident as the author of this synthesis, Morton Horwitz, looked around the world that he saw. Another approach to the mirror was to imagine that the mirror would reflect the forces of social life outside of the law. Now here is a different question that's being posed, and I think it's a question that legal historians are pursuing today because it's a characteristic question of the 21st century. The question here is, does the law have the power to shape social life? And does it even have the power to act as a magic mirror to capture all that's going on in social life? The 21st century has posed problems for the law. Globalization has posed problems for legal systems that have been organized around states. And in a moment when states suddenly don't seem to have the jurisdictional capacity to accomplish the kinds of things we might want to accomplish. And this is a question for a post-9/11 era in which emergencies have raised real questions about the capacity of the law to catch hold, to bind, to constrain, to shape the social life and the political life of this country and of other countries as well. So what we see in this book is history being used as a device for making sense of whether or not the law can catch hold in a world in which there are other forces, other enormously powerful forces that bear on social life, that are competitors with the law. And so we see them here as war, we see them as economic transformations. In some ways, some of the kinds of things that historians of the longue durée in European and American social life might point to as the drivers of history: war, economic transformation, or microbes. I mean, there's a really interesting early part of this book that focuses on the effect of the introduction of Eurasian germs into North America and South America too. So these are powerful forces up against, and law is up against these powerful forces. And so the project of the book is to see if the through line of the law can capture some ongoing constitutive significance for this fragile practice in the midst of these very powerful competitive forces. this makes me think of legal history as something of an optimist's game. It's a hopeful practice. It's the practice of trying to find a space for ideas and for ideals in the long history of human social life. And I think this book lives up to that optimist's approach. It's an optimist's book, I think. And so what we see is law having continuous constitutive significance in wartime. We see law hanging on to hanging on even amidst the violence of the settler communities of colonial North America. We see law shaping the ideas of the revolutionary generation and the constitutional history, saturating the mental landscapes of the founding generation. We see the Supreme Court's fragile beginnings and eventually getting to a robust mid-19th century institution. We see law working to shape the legal architecture. That's Ted's language, legal architecture. I think it's a really great way of putting it. The legal architecture of the fugitive slave, such that the fugitive slave and the politics of the fugitive slave aren't just contending interest groups, but are instead constructed by, and even as they reconstruct, a field of legal practice. And then most of all, at the very end of the book, the beautiful ending in which the Civil War is an experience not just of clashing armies with something like 3 million soldiers in the Civil War with 600,000 deaths, not just an action of brute force, but instead an action that's shaped by the legal architecture that it inherited and reconstructing a legal architecture through a set of legal conversations and legal institutions. So that's when I come away from this book, that's what I think. It is a synthesis for the 21st century. It's a synthesis that asks about the capacity of the law to be constitutive in a world in which there are many competitor powers and many competitor institutions. So I'm glad to have this book as the first synthesis of the 21st century of American legal history, and I think we'll read it for many years to come. So thank you.
Well, it's very nice to hear people say the occasional good word about one and one's work. When Liz and I first started talking about the prospect of this session, I said I wanted it above all to be a basis for exchange. I didn't want it to be overly celebratory. I didn't want it to be overly descriptive. So I'm going to simply thank the commentators for what good things they've said about me and try to take up some of the other things that they've either asked me to clarify or suggested that they may have wanted a different treatment. I'm sorry that Tomiko, that you had to devote so much time to saying nice things because you were just getting started at the end, and I would have liked to have heard more about that. But I will say, let me say, I'm going to sort of take the comments somewhat in order, although I'll try to integrate the comments because there's some overlapping themes. So one question that Tomiko asked me, and I want to answer at this point, although perhaps the answer is obvious, is how my methodology connects to the contributions of Bob Gordon, who is my age contemporary, and who is famous for basically reorienting the direction of at least one and maybe two generations of legal historians by getting them to think about the idea that law is neither wholly autonomous nor wholly dependent on its external context, and that the relationship between law and that context, as I put it, is both constitutive and reflective. And I simply associate myself with Bob's comments. We come out of rather different traditions, but we certainly share that view. And this book is an effort to perpetuate that view. So people are quite right. I reject the mirror hypothesis, even if the mirror is very badly cracked, I reject it. And what I'm interested in substituting for that is something like what John Witt has said. I think the way I would put it is that I think of law, or I'm trying to get the readers of this volume to think of law as, at least in America, as deeply central, very important, continually aspirational, and also beset, repeatedly beset by forces, if you will, including thinking of ideas as forces, but forces from the larger culture that threaten it, and particularly threaten its capacity to provide social cement and serve as an aspirational force. And the problems that these assaults present for law is that part of its attractiveness as aspirational and central is that it is supposed to transcend politics or human disagreement or passions or war, and yet it comes close to the edge in this volume repeatedly of failing. It fails because in the colonial period, as the Amerindian cultures interact with the settler cultures, the relationships of the tribes are largely obscured, wiped out, if you will, marginalized. And then what emerges is a legal system that really serves to continue that marginalization. It fails with respect to the importation of African slavery, first by recognizing it and legitimating it in the Constitution and in certain states. Second, by awkwardly assuming that it will somehow disappear, but then through Congress, through the political parties, through the Supreme Court, allowing it to flourish, allowing it to become a force for what I call dissolution. And although the assaults are, although one can be sympathetic in a way to the aspirations of law, because it's a deeply pluralistic, growing society, on the whole, law and legal institutions through the period from the 1830s through the 1850s do a rather poor job, in retrospect, of facing up to the implications of flourishing African American slavery in a period with great territorial expansion. So John Witt is largely right, and Fred Kanevsky is also right in thinking of this as a volume that is constantly trying to juxtapose the idea of law as culturally central with the ways in which it fails wholly to achieve the kinds of aspirations that Americans build into it. Now, let me say a couple more things about that. I have basically four interrelated themes in this book. One is, and they've been described well, particularly by Fred's synthesis. One is the Amerindian interaction, the interaction of settlers with the original occupants of North America. The second is the emergence in the late 18th century and again in the early 19th century of the agricultural household, both slave forms and wage labor forms, as the central central social and economic unit, and how that emergence ended up being a force for dissolution as well as a force for economic transformation and the growth of the United States as a powerful nation. A third is the complicated relationship between liberty and sovereignty as those terms were understood at the time of independence and in the framing of the Constitution, and how those terms interacted in an unfortunate way with dispossession of Amerindian tribes and with slavery, so that sovereignty became an argument not just for leaving the British Empire, but for retaining a slaveholding system in certain states or from driving American tribes out of those states. And liberty became a vehicle not only for developing freedoms, but for the freedom to hold others in various conditions of servitude. We shouldn't forget that one of the principal reasons that the Dred Scott decision concluded that after many years of the assuming that Congress had the power to outlaw slavery in federal territories, all of a sudden Congress couldn't do that because it was an infringement on the liberties of slave owners. That is, that's what due process meant in the Dred Scott decision. So that theme then is that liberty and sovereignty, two of the great defining concepts of the American nation, also became internecine conflicts. And then the last theme, which leads us to the Civil War period, is the toxic interaction of these earlier themes. That is, the clearing away of land on land formerly occupied by Indian tribes so that settlers could move westward, the United States having expanded its territory at a time when most of the inhabitants of the new territory were members of tribal nations, but they simply were not regarded as counting as occupants. They were in the way of settlement. And so the first step in territorial expansion and westward settlement is the dispossession of tribes. Another very important step is the idea that slavery could flourish as an economic and therefore a social and political institution in the Trans-Appalachian and Trans-Mississippi West. And so just at the time when territorial expansion takes place and American populations grow and begin to settle that area, the prospect is raised that slavery will not die out, as the revolutionary generation expected, but that it will flourish. And then finally, the successive efforts on the part of Congress, the national political parties, the Supreme Court of the United States to contain or diffuse this toxic interaction by the Missouri Compromise, the Compromise of 1850, the gag rule about talking about slave issues in Congress, the Kansas-Nebraska Act, and ultimately the Dred Scott decision. And in each of these instances, the law and legal institutions decided either to postpone the awkwardness of this mix between slavery and territorial expansion, or finally, when time appeared to be running out, the Supreme Court of the United States tried to settle it definitively. Tomiko asked me at one point, did I just think that the Dred Scott decision was a failure of rhetoric? No, it was a failure at every level. The court's decision-making process, the relationship between the decision and the other branches of government, the invitation extended tacitly by the court to other branches of government to try to let us settle this question. The disastrous arguments emphasized the choice of the Taney opinion as reflecting the opinion of the court, and finally the disastrous arguments about citizenship and freedom to hold slaves that ended up becoming understood to be the prominent features of the opinion. So the story I'm trying to tell, and Tomiko and Fred and John have captured it very well in their remarks. The story I'm trying to tell is a bit of a downer, but it's also, as John puts it, it's also intended to be optimistic. That is, it's supposed to be a testament to the centrality of a nation that is, after all, dedicated to the principles of liberty and sovereignty and rule of law, beset by other powerful threats, not always holding up, sometimes contributing to them, but enduring and recovering. So in that way, it's optimistic. Now, the last thing I want to say is about false modesty. I do get off some occasional humble comments in the narrative, but they're meant philosophically. They're not meant personally. You should take them as akin to Holmes's musings about mankind has no more cosmic significance than a baboon or a grain of sand. Or I am just like a rock in a river letting water roll over me. Holmes liked to say that because he thought it was philosophically arresting. He never thought it actually applied to him. Thank you.